Assalamu alaikum, good evening and welcome to the Ask Aman live stream. Thank you very much for joining us today. We hope to have a informative and interesting program for you. But as ever, before we start, just a bit of introduction about what we can and cannot take from this show. And secondly, just a short video setting out the services that we provide.
Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Welcome back. Thank you very much for joining us. So today we're going to cover three key issues. Firstly, it will be employment law with my colleague Saad Said. Assalamu alaikum, Saad. Good evening and welcome.
Wa alaikum assalam. Good evening. Welcome to you as well.
Thank you very much for joining us. So we're talking about employment law and whistleblowing. So why don't you just open up, just to give us a little bit of introduction. What does whistleblowing mean? As the name suggests, it's obviously drawing attention to something, but if you can translate the jargon into simple English for us.
Yeah, inshallah, I'll do my best. Okay, now let's start off with a bit of background then. Some of our older viewers may remember some of the disasters that happened in the 80s and 90s, such as the Zeebrugge ferry disaster, the Piper Alpha oil platform disaster, and in the late 90s, early 2000s, there were a series of rail crashes as well, including the Clapham rail crash. As a result of the investigations and the inquiries of those disasters, it came to light that there were, for example, some things which were going on in the workplace which were not good and may have contributed or led to such bad practices which may have in themselves contributed to the disasters happening. So what happened is that the government passed what we call the Public Interest Disclosure Act in 1998. And that then allowed employees, workers who were concerned about bad practices happening in the workplace to tell somebody about it. And it gave them the right not to suffer any detriment as a result of making any statements such as that, or to be dismissed from making such statements. So that's the background. So when we talk about whistleblowing, we're talking about somebody who says something in the course of their work, which really is something which may lead to something which could become bad later on, or as bad practice, or potentially even worse.
So basically what you're saying is, if you're at work, you know that your manager or your colleague should be going along certain standards or using certain materials if it's construction, or if it's some sort of a high-risk job or high-risk environment, they should be following certain procedures. And if they're cutting corners or are being negligent, that endangers life, it could endanger safety, and therefore you would be entitled to go public and you should not face the sack. Is that what whistleblowing is?
Effectively, yes, that's right. And what I will discuss or talk about now is that when you are making a disclosure like this, when you are saying something or revealing something, what categories, as per the law, should they fall under in order for them to be protected? When we say protected, i.e. you to have your rights not to be detrimented or dismissed. So there are 5 main categories under which a person who makes some kind of statement or disclosure, as we call it in legal terms, has to fall under. So first of all, a person who is concerned that there is going to be committed a criminal offence, or is likely to be committed a criminal offence, or has been committed a criminal offence, can make a statement to his employer about that and not suffer any detriment or be dismissed.
What you mean there is, do you mean that somebody will see that people in the workplace are committing criminal offences, breaking the law, and if that happens, when they raise the alarm, tell the authorities, no negative consequences?
Exactly, that's right, yes. That's the first category. Okay. Second category is where there has been or is being conducted or likely to have been a miscarriage of justice. So if you see that happening in the workplace and you raise that or raise the alarm regarding that, then again, you are protected under the eyes of the law.
Okay.
The third category, as you've already alluded to before, is where the health or safety of any individual has been or is being or is likely to be endangered. Okay. The fourth category is where the environment has been, is being or is likely to be damaged. And the fifth category is where a person has failed to comply with a legal obligation or is failing to comply with a legal obligation or is likely to fail to comply with a legal obligation.
Okay, so basically those are the categories. And what's the time limit for this? I mean, how long can things go back? What's the limit on the disclosure?
Okay, well, the limit on disclosure when we're talking about bringing proceedings in the employment tribunal, for example, will be 3 months or 6 months. You can only go bring a claim if you suffer a detriment within that time period.
When you say detriment, basically you suffer. So you are demoted, you're being harassed, you're being told you're going to be sacked, or you get unfairly treated. I mean, detriment here is something like that, right?
That's right. So when we talk about detriment, let me split it up into two categories. There are detriments which you may suffer while you are in the workplace, but you are not dismissed. Okay, so some other kind of detriment that you suffer, maybe you are demoted, or maybe your pay is reduced, your hours are reduced, or something like that. And the other detriment is actually being dismissed in itself. Okay,
understood. And in terms of well, look, sometimes you can make a mistake. So let's say I'm a relatively junior member of staff. I don't understand fully, but I think I have spotted you or somebody else breaking the law, so doing something which is wrong. If I go public, what's likely to happen as a result of that? If I make a mistake, honestly and sincerely believing it to be correct, but it was wrong.
Okay, now, if it happens to be wrong, what the law says is that as long as you reasonably believed it to be true or correct, and as long as you had a reasonable belief that that was indeed the case, then it matters not whether it was right or wrong. You are still protected under the eyes of the law. Now, let me explain one thing here, because when somebody makes a statement about coming within one of those 5 categories that we've identified, it does depend to whom that person makes the statement as to whether the reasonable belief is enough or not. So let me explain. So when an employee or a worker, because we have to remember that these rights apply not only to employees but also to workers as well.
Okay.
If they were to make the statement to their employer, to the person who's responsible for the relevant failure, or to a legal advisor, or to a minister, or to another what we call prescribed person, then they only have to have a reasonable belief that what they say is true. Okay. However, the worker can also make disclosures to other persons who I've not mentioned, or to the press. But if they were to make that kind of disclosure to somebody else not in the list, which I've already read out, or to the press, then they must believe that the information that they have disclosed is substantially true. Okay, so there's a difference there. There's a higher threshold. If you're not going to be making the disclosure to those 5 people that I've read out, the allegation has to be substantially true, not just having a reasonable belief, but substantially true.
So the 5 people, just remind us again, because those are people connected to the company, linked. So this is not going straight onto YouTube or Facebook and telling the whole world, because there you need substantial belief there's got to be some substance to it, higher than what would normally be required or acceptable in the workplace for somebody linked to the job.
Yeah, that's right. So just to repeat those categories, 5 categories of people, you can make the disclosure to your employer, to the person who is responsible for the failure, to a legal advisor, to a minister of the Crown, or to some other prescribed person prescribed under the eyes of the law.
Okay, so this is basically not going public and splashing it on the front page of every newspaper and onto social media. My company's, X, Y, and Z, and my colleague, John or Abdul, he's an absolute crook, blah, blah, blah. You couldn't do that. There will be consequences. So people perhaps could take legal advice and speak to somebody before, if they're not sure, just to establish that what they're doing is right, because you don't want to destroy or trash the reputation of a company or a business wrongly. That would be
Indeed.
Not very nice for your own career prospects either.
That's right. So the way of looking at it is like this. If a disclosure is not made to one of these 7 categories of people in the list, then you're not protected under the eyes of the law.
Right.
Obviously, then it doesn't fall within the category of being whistleblowing. Therefore, if you do suffer any detriment or if you are dismissed, it may not be unlawful. You won't have any rights in relation to that. So you have to make sure the disclosure is made to the right category of people.
Well, let's say I make a disclosure against somebody and that person takes it personally, speaks to the manager of the company, then decide they want to sack me. Is there a minimum time limit, or are there any other conditions which apply regarding unfair dismissal in those circumstances?
Okay, so a few weeks back we covered unfair dismissal, and I said to all of the viewers that there's a general rule. You only have the right to claim an unfair dismissal if you've worked for your employer for 2 years or more. However, when it comes to whistleblowing, there is no qualifying period. So you could have been in the job for even just 1 day. If you suffer a detriment for making a disclosure, then you can claim, if you're dismissed, let's say even after 1 day, then you can claim the right that you were unfairly dismissed for reasons of whistleblowing.
Okay, you talk about detriment and dismissal. What's the difference between the two? I mean, if you're dismissed, does that make your case stronger, or if it's detriment in the workplace? Just tell us a little bit more about each of those, if you will, please.
Okay, fine, right. So I'll work backwards, because it'll probably be easier for me to do that. So in the case of somebody who is dismissed because they made this disclosure because they blew the whistle, if the reason why they were dismissed was entirely due to that or connected in any way to that, then the person under the eyes of the law would be deemed to be automatically unfairly dismissed. And as I've said, even if that person was dismissed after working in the job for 1 day, they can claim an unfair dismissal. And if they were to succeed and show the tribunal that this was the reason why they were dismissed, automatically it would be held that they were unfairly dismissed under the eyes of the law. Now, working backwards then, if somebody is not dismissed for making this disclosure, but they suffer some kind of other detriment, and the law says any detriment whatsoever, then that is also protected under the eyes of the law. And when we talk about any detriment, it can be absolutely anything, but it has to be at the end of the day a detriment. So it has to be you receiving some less favorable treatment when compared to how you were being treated before you made the disclosure.
But you must prove that what you're saying is the case, yeah? You have to prove your case. You cannot basically point the finger without establishing that there is an actual detriment. So the duty is upon you, if you make the allegation, to prove it.
The detriment? Yes, of course, yes.
Okay. In terms of the compensation or what you can get. So what are the limits, if any, on compensation? What are the any other limits in terms of the remedy or the justice that you can get if you are wrongly targeted and suffer a detriment as a result of whistleblowing?
Okay, so again, in the case of if you were dismissed as a result of whistleblowing, again, a few weeks ago when I talked about unfair dismissal, I may have mentioned that there is a cap on the amount of compensation you can normally be awarded by a tribunal for being unfairly dismissed. Now, in whistleblowing claims, there is no cap to the amount of compensation that you can be awarded. So that is one very, very important difference in the eyes of somebody who's dismissed for some other reason, as opposed to somebody who's dismissed for whistleblowing.
Okay, so just to draw the different strands together, sort of bring everything together for us in bullet point format, if you can just, if I can ask you to just summarize what you just said in the last 10 minutes or thereabouts, where we are with all this, that would be really useful. Just literally a few key bullet points, 2 minutes, if you will, please.
Yeah, certainly. So, as I said before, if a worker, okay, not necessarily an employee, but a worker thinks that there is being or is likely to be committed or has been committed a criminal offence, or a failure to comply with a legal obligation, or a miscarriage of justice, or somebody's health and safety is being endangered, or that the environment is being damaged, then they're entitled to raise this with their employer and make an allegation or a disclosure, not an allegation, sorry, a disclosure that this is going on or is likely to happen. And as long as that disclosure is made to the employer, to the person who is doing or responsible for the failure, or to a legal advisor, or to a minister of the Crown, or to another prescribed person, or even to somebody else not on the list, or to the press, then that person is protected under the eyes of the law, and they cannot suffer any detriment at all as a result of making that disclosure. That's a summary of what we said before, but I want to add one other thing to this. So we've talked about the disclosure and about what kind of category of disclosure it has to be and who it has to be made to. The other thing that is required for a worker to be protected under the eyes of the law is that the disclosure has to be what we call in the public interest. Okay, now this is not such a big thing. So when we talk about public interest, it's a very general and simple test to meet. So in a nutshell, the public interest is defined as any disclosure that would serve the wider interest other than the personal interest of the worker who's making the disclosure or the private interest of the worker who's making the disclosure. So as long as it affects or could potentially affect 2 or 3 or more people, then it may well be deemed to be in the public interest. And it's really as simple as that. That is a summary of the law regarding whistleblowing. Hopefully now you understand what whistleblowing is, what the legal requirements are, and you understand your rights if it were to happen to you, what you can do and what you can claim in the tribunals.
Excellent, Saad. Thank you very much for that. So that was the summary of the law on whistleblowing. Now I'm going to just briefly talk about education law, public law, and the duty of consultation, which is incumbent upon the schools when they are rolling out relationship education, relationship and sexual education, relationship and sexual and health education. There was a lot of discussion about this in the last couple of years when this measure was passed into law. And if you are a parent of children at any school, the government have published guidance, which is a mandatory guidance that schools must follow when they are dealing with this matter. So the schools must consult parents about how they're going to teach this. Now, these types of lessons or this type of education was due to start last September, but due to COVID, it's come to my attention that many schools have not started teaching. In fact, many local authority and local areas have delayed it to September of this year because they were not able to carry out any meaningful consultation where many parents sought that consultation. So if you are concerned about your children and about what they will be taught, then there is a structure or a process to follow. Firstly, what you must do is make your desire to be consulted known to the school. The school have an obligation. They're required to consult parents in terms of their views. And so in this regard, you will send an email, a letter to the school, something verifiable. And if the school has outsourced the consultation or co-opted somebody else like a local authority, then of course you need to find the relevant people and to send it to them too. Now, in particular with migrant communities, language is very often a problem or a barrier to understanding what is going on. So it will be useful if you can make known to those parents who are not native English speakers or English is not their first language and would not understand. So the maximum number of parents ask, demand, request consultation in a conciliatory manner. Ultimately, you have to cooperate with the school and with the local authority to make sure that the process is undertaken with a view to achieving an outcome which is acceptable to both parents and the school. Now, there's no choice about whether or not this will be taught. That law has been passed, and unless somebody wishes to challenge that, which is a separate matter for a separate day, we're talking about what gets taught. So first of all, the syllabus, or the syllabi, plural, and policies have to be drafted, and you must be alert to the fact that you're not shut out of that process either through oversight or through agreement. So you will make sure that you will say, we want to be consulted, and you could come together and put together an unincorporated association or incorporate an entity, a company, which then is in charge of helping people come together and to communicate with the council. This way, we can get people to speak English fluently, who are professionals, who are articulate what needs to be said, and they can then put together paperwork and documents. Now, if you make that known to the local authority in the school and they don't agree, then you have legal remedies. Now, if the school and the authority come back and say, okay, we want to just nominate a handful of people or do it in a particular way, again, you've got to demand what is reasonable and what is fair. With COVID, the way things are, it may be that you'll have to possibly settle for something less than face-to-face, but I think face-to-face is possible as the country is opening up with appropriate safeguards in place. But either way, you should have somebody advising, assisting you who understands how this process is to work. You will need teachers on your side, educators, and possibly experts, because the law requires teaching at primary schools, secondary schools also. And therefore, what needs to be included in the syllabus is one thing. And if you can come up with a document or documents which can go to the school or the local authority to say, look, or the academy or whoever it might be, here's what we want you to teach, then you have a process for negotiating and you're not beating around the bush or chasing your tail. Once you've got past the syllabus and the policy stage, then there's the materials that will be used, the lesson plans and so forth. And again, here, there is a lot of concern for many parents about age appropriateness, particularly for primary schools, where clearly the sexuality of people is something which there is dispute about. There's disagreement about that. And ultimately, how things are taught, particularly to primary schools, you can particularly influence because the social and cultural sort of religious background of the pupils and the number of people of faith, for example, who are at a particular school is a matter that must be taken into account. And hence, the consultation requires you to put in representations, go to the meetings and so on, and make sure you are heard. Everything is documented. So if you've tried that, particularly in schools where it's been delayed, deferred to September this year, which is very likely for many, then if you are at any stage unhappy, you should take legal advice and then, if necessary, take legal proceedings. Now, in all of this, remember, the teachers are not your enemies. This is not erecting barricades and, having a go at each other. Ultimately, there's got to be an organized way of doing this. But if people are not listening to you or ignoring you or sidelining you and other parents, then your only resort will be to take legal action. And this can be best done if you come together with a number of people, because like with anything else, there are costs involved, and you will be able to fund it through both collective action in terms of sharing the workload, and then fundraising amongst parents and other people to actually get the money together to get legal advice to help you ensure that, one, you're not being unreasonable, because it may be that the school or the local authority are being perfectly reasonable and you're being unreasonable, in which case taking a case to court will only be costly for you, and it could backfire because that'll create a relationship which is not harmonious. Whereas if they are being unreasonable and you have live advice, professional advice from people who know what they're doing and what they're talking about, then clearly the school will be alert to that, the local authority will be alert to that, lawyers will be alert to that, and you may well be able to negotiate a settlement either in relation to the syllabus and the policy, or in relation to the materials that are going to be used, that people are going to be involved in teaching and what will be taught, particularly in primary schools where certain things are not obligatory, whereas in secondary schools, there's much less choice as to what can be taught. And again, you can delay things to the end of the first year of primary school, and again, with secondary, potentially seek to delay it to the end of the secondary school, with the age rather where children will be a lot maturer, because there are horror stories of children being taught things about human anatomy and so on. They go onto tablets and are directed to sites. I mean, I've heard anecdotally of children ending up on pornographic sites and what have you. If you type in genitalia into a search engine or something, then the algorithms may well take the kids where they don't need to go. So this is where these concerns are very real, very relevant and very valid. And ultimately, parents will have different views on this. The more conservative you are, the less likely you are to want to agree to the things being taught in primary schools, or you may choose to teach certain things yourself. So ultimately, you cannot turn the other cheek, walk the other way, and then complain afterwards and start arguing with schools when things were not approached at the right time. Now, in terms of litigation, of course, litigation is not something which is to be done lightly, and it's not something which is necessarily very cheap either. And hence, full involvement in the process is important, because if you did not involve yourself in the process and then you come right at the 11th hour when everything's been done and say, I don't agree with this, I don't agree with that, and the school says, well, we sent a letter home with young Johnny or young Miriam, and we sent you an email, and we spoke to you at the school gates, and here it is all documented, and many other parents will verify that, then the general principle in public law is that if you didn't participate in the consultation, if you did not take the opportunity that was afforded to you, then you will not, generally speaking, be allowed to come along and start arguing and raising points which you could have and should have raised at the right time. Furthermore, expert evidence, particularly if graphic or semi-graphic content and materials are going to be used with regard to primary school children, will be very important. Now, you can get behavioral experts, child psychologists, child psychiatrists, and people who specialize in matters which affect the development and behavior of young children, particularly primary school children, also young secondary school children. Here, expert opinion will carry a lot more weight than I don't like it, I disagree with it, because the law says, well, you've got to take account of religious and cultural values, but they do not carry the day. They are not determinative. They're not going to be enough. But of course, if the population of the school is 70%, 80% religious, whether it's Muslim, Jewish, Christian, or Hindu or Sikh, and people are conservative, and they say we don't want X, Y, and Z done, there's much more of likelihood that you will achieve the result you want. Whereas if it's much less and the general opinion is against you, then it's unlikely that you will get the traction that you wish in the school. So take the opportunity, be concerned with the school, contact the school, remain in contact with the school. And if you're one of those parents who are not consulted, just to conclude, and the school has already started teaching, whether it's in September last year or in the summer term or spring term coming up, then you may well have a case if you were not properly consulted, if notice was not given or sufficient notice was not given and the process was not fair. Again, you will need to take advice from people who understand public law, education law, school teachers, lawyers, solicitors, barristers, and so on, so that you're not effectively running into a cul-de-sac and with no way to get out. And that's very, very problematic, because then you could end up spending a lot of money, end up becoming a victim rather than achieving a success. And this is the general view with regard to schools and college or education law, that you've got to be involved at the right time, take the right steps, and pursue it in the right way to ensure that if the decision is unlawful, unreasonable, and wrong, that you have an appropriate remedy through the courts if necessary. Litigation, of course, is a matter of last resort, not first resort, and the courts are not very keen on people not following the proper process. I hope that clarifies the law and the procedure that you should follow. And inshallah, if you need any help from us, we are here. And if not, you take advice from suitably qualified professionals who can assist you. I'm going to now ask my colleague Adnan Mahmood to join us, and we're going to talk a little bit about civil litigation and freezing injunctions. So, Assalamu alaikum, Adnan. Thank you very much for joining us. Good evening.
Wa alaikum assalam. Good evening to you.
Right. So, freezing injunctions. Tell us today, what are you going to talk about in terms of somebody getting an injunction or somebody trying to set one aside or get rid of one?
Today, the focus will be on anybody who's seeking to obtain a injunction for their own benefit.
Okay. So here I am. I've been the victim of a scam. You know, John Bloggs and Abdul Khan have convinced me to buy some electronic goods. I pay the money, and then I see a scam alert. That company and their details have come up. What do I do? what can you do? I've electronically sent 40,000, 50,000, 100,000 pounds over. It's the same day. I'm stressed. What do I do?
Okay, well, if the money is available, assuming that the money is still available and we know which account or accounts it's likely to be in, then what I would be advising you is that you need to think strongly about obtaining a freezing injunction, which is an order that you can obtain from the court to freeze those particular assets wherever they are held.
Okay, so you've convinced me. I'll phone you up. Look, I've spent a lot of money. Now, most people start having nightmares and start sweating buckets, lawyers, injunctions. How much is it going to likely to cost me? Indicative. Let's say it's a case where just me, it's one transaction. There's not a lot of documentation. What would I need to give you up front, as it were, to get the case going? How many thousands is it? Is it tens of thousands?
Well, freezing injunctions are injunctions which aren't made just with one application. You're not likely to have just one hearing.
Yeah.
If you get an injunction, which most of the time it's done without giving the other side notice, because you don't want them to be told about it, otherwise they'll quickly get rid of the money.
Yeah.
So it's usually done on what's called an ex parte basis, where the injunction is then, if it's granted by the court, then the matter doesn't end there. The procedure would dictate that the other side then has to be told about it. Otherwise, if they're not, there'll be a gross injustice. What if you're just telling lies and this money wasn't actually yours in the first place? So then,
okay, so you
another hearing.
So because most people will be thinking, okay, I need to know where I'm going. I don't want to spend more than what I'm going to recover or substantial amount of money if there's no end in sight. So would you be able to give somebody, once they discuss with you how much money up front at each stage, so at least they can budget reasonably? Obviously, these things are not cast in stone or in tablets of stone, because things change. So are we looking at thousands of pounds or tens of thousands in the beginning? What would somebody need to put up to get you going, get you out your blocks?
Well, in order to apply for the emergency injunction, the person will be looking at around about £2,000, approximately. That's for the initial stage, but then it's all on a stage by stage basis, because it may be that after getting the injunction, the other side say, "Oh well, we've been caught, we've been had, there's nothing we can do," and they don't defend it. In which case, then there's not much extra cost. But if they do defend it, if they rigorously say, "No, this money is perfectly legitimate, it's not been taken from you," then it's likely to be contested. Then you'd be looking at tens of thousands of pounds.
Okay, so we've got it going. What would you need from me immediately? Just give me an idea. So take an example of a case you've dealt with, or give us an idea. So people are in this situation, they know exactly what to collect, what to grab, what to email you, so that you have everything to hand as soon as possible.
Well, first thing is facts. The first thing that we need is what is the story? And that's usually put in the form of a statement. So whatever the case is, i.e. you bought an X item, paid this much money. We need to know the full history of the events, as to what got you to this position where you no longer have this money and you've been duped in a way. Now that's number one, and that's put in the form of a witness statement, which has to accompany the application, which a judge would then look at. Hello, are you there?
No, I'm here. I'm just sort of giving you the full screen. So you carry on.
Right,
sorry.
I thought I was a man there for a moment. So number one, we need full facts. We need to know exactly what's gone on. And on that basis, a witness statement would then be prepared, which would then set out for a judge an easy to understand story. Now, it's important to know that when I say facts, I mean full facts. With civil litigation, especially when somebody is applying for some kind of an injunction, like a freezing injunction, you have to give full facts. These have to be told to the court. So even facts which are not in your favor, this is called full and frank disclosure, they have to be told to the court. So, for example, you can't say, they've taken, say, £40,000 from me, when in reality they've only taken 30,000 and 10,000 was held back for any reason. That's not giving full facts. and there could be serious consequences for not giving the full facts to the court.
Okay, well, this is quite important because you sign declarations on witness statements, and if you are proven to have perjured or withheld something which is important, which would have affected a judge in making a decision, what are the likely consequences? I mean, can you end up in prison? Can you get, told off? And what? Because people need to be clear and come into this with their eyes and ears open.
Right. One of the things when you obtain a freezing injunction is that you need to give a promise to the court. It's known as an undertaking. And this promise to the court is where you're letting the court know that I've given you all of the facts for full and frank disclosure. If, however, it subsequently transpires or the court finds out that I've not given full facts or I've not told the truth, as a result of which, the person whose assets you've frozen has now suffered damage or harm, then you would be, number one, you could be liable for their costs. That's one of the promises that you give, that I will pay their costs or their damages that they suffer. If it subsequently transpires that I've not been truthful about the facts that I've told the court, and yes, it's also considered a contempt of court. So you could be imprisoned, you could be fined or even imprisoned.
Okay, so I'm calling you. This is just Friday afternoon. You're just about to go home. I've just realized that my brilliant deal of 50 Apple Macs and HP laptops is in fact a big con. I call your office. I've just TT'd the money. What am I going to have to do? Wait until Monday, or would you be able to, if necessary, work and get something for me on a Friday night or even the weekend? Because by Monday I may well not be able to get anything back. Would you be able to do that? And is there a premium for working, out of hours and weekends if people want that service?
Well, yes. In short answer, yes, we can. Freezing injunctions are usually applied for on an emergency basis. It's usually because you need to protect the assets. If someone's taken the money from you, there's a strong possibility that it may not, although it's in their account today, it may not be there tomorrow. And if you call on a Friday, there's a risk that by Saturday it may have gone, and by Monday you're left completely out of pocket.
But the courts are closed, so what are you going to do? I mean, I'm trying to understand, how does it work if the courts are closed at 4:30 on a Friday?
Yeah.
What do you do?
Well, the courts are closed, but not all of them are. There is a special procedure for emergency applications. These are out of court hours, where a judge, which would be a high court judge more than likely, would be sitting, probably playing golf somewhere, but you'd be disturbing him by saying, I need this application dealt with. But on that particular judge who's assigned for that evening would have a clerk who is working for them, who you would email the papers over to, and then you could that would be presented to the judge. You're then put on the phone. Oh, sorry, my light's gone off. You'd be put on the phone to the judge, who would then consider the application, hear your arguments, and then decide whether or not to make the order. I mean, that gives me I remember one such example where we were sitting. It was out of office hours for us. We were sitting in a restaurant one day, all of the staff, and had a client on the phone who needed to get an emergency injunction. And the beauty of technology is that we were able to draft the order, prepare the documentation while sitting in the restaurant, get before a judge, and get the injunction that very evening.
Excellent. That's very good. So it's all available. Now, what do you have to prove? So I've convinced you, I've said to you, I'm telling the truth. Honestly, Mr. Mahmood, I wouldn't lie to you, I swear on it. You've got my paperwork. I've got you the emails. I've got the bank transfers, all the contracts, etc. And the promises that, look, these are all good. And all of a sudden, I've got the scam alert. So I've convinced you. What do you have to prove to a judge? I mean, you mentioned ex parte that you're going there without notice. So the judge has to be satisfied, or is there some sort of legal standard or legal requirement that you have to prove, i.e. on my behalf?
There is. It's not just as simple as saying, sir, I had this money, I no longer have it, this person's taken it from me, please can I have it back? There's certain legal requirements which need to be met. And these are these come from a famous case known as American Cyanamid. And in that case, the court laid down a test, certain requirements which need to be met which a judge needs to be satisfied of before he grants you the injunction. And those are essentially, number one, there must be a serious issue to be tried, meaning that the court has to be satisfied that you have a case, that you have a case to argue, that you did have a contract. There was obviously, a court's not going to carry out any fact-finding exercise at this point without hearing evidence from both sides. But a court has to be satisfied that you have a case, which does require the court to consider it.
Okay, so we've got past that. What's next?
Do you have that? Then you have what's called is, could damages be an adequate remedy? So, for example, could you be compensated in any other way that would alleviate the need for the injunction? And if you're saying no, I'm £40,000 out of pocket, that I need that back, then damages technically could not be an adequate remedy for you. You would need the exact money which you've lost to be returned to you.
Okay,
Next
so
one, the court then the court looks at balance of convenience. What harm would it do for the injunction to be granted? Is it likely to do you more harm, or is it likely to do the other side more harm? Now, a judge is going to think, look, I'm faced with an option here of temporarily freezing the other person's bank account to stop them from spending this money. If I don't do that, then potentially there's more harm to you, because if it does transpire that that money was yours and you've been unlawfully deprived of it, then there's far more harm to you, because there's a possibility that you may never retrieve that money, albeit the temporary inconvenience which may be caused to the other side for not being able to spend that money in the meantime.
Sorry, now can I just pause for a second? We've got a bit of a problem. Let's try and...
I'm not sure where Basharat's gone. The technical problems seem to be persisting. I'm not sure if they're at my end, but I'll hopefully continue for the benefit of the viewers.
There was a bit of a technical... We're back together. Sorry.
I was about to take over your role.
Sorry about that. So we got to the point where the balance... to everyone for the... you couldn't plan this sort of thing, could you? For the technical glitch. Honestly, I've got Virgin internet connections, but there you go. So you said balance of convenience. So obviously, if we're going to say that it's a crook, he's going to take my money and stick it on the floor. I think I might take you up on that offer, Mr. Mahmood. That sounds like a good idea. Right, so, okay, balance of convenience is there. This guy dodges a £25 note. We can convince the judge, so the balance of convenience is in our favour. What's next?
Well, that's it. A judge should be satisfied that an injunction should be granted. And what would happen then is that an order would then be drawn up, or ideally what we would do is we would prepare a draft order for a judge to approve, for him to then go through and tweak here and there wherever he or she feels it needs tweaking. That order is then sealed, and then what we must do is then serve it on the bank. So for example, if we're looking to freeze a bank, immediately notify the bank, and banks have designated departments which deal with this kind of thing, where once they receive a freezing injunction, they will immediately freeze that particular account which you're looking to freeze, or any other account which that person holds. And if it's usually,
what about,
sorry?
Let's say I know that he owns a property. Let's say we know that he has, I don't know, he's got a horse and a yacht. So let's say I've known this person, I've been scammed. So would we try and freeze everything and say, if you try and dispose of them, you're going to go to prison or things like that?
Yes. So properties, for example, you'd serve the order upon the land
Is that
registry.
done? I'm here.
We'd serve it upon the land registry. If they have assets all over the globe, for example, there's even the option to get what's called a worldwide freezing injunction. And that has the effect of freezing everything. But obviously, once you have it, all you have in your hand is a piece of paper. That's worthless. That piece of paper needs to be put on, needs to be sent to the relevant departments and agencies, etc., so that they freeze the account, freeze the asset, and then it's served upon the actual individual who's concerned, so that they're put on notice that if they now try and get rid of any assets which we haven't been able to freeze, because, for example, it's a personal asset like a yacht, where there's no particular registry, then he would face serious consequences if he or she tried to dispose of it.
Okay, so you've got the order. We found him. We've given it to you guy. He's lying, and he tries to then, get. He has to explain his side of the case, and then, as you said, is that like a full hearing where the court has to decide whether the injunction carries on, the freezing order carries on? Quite
right. It's known as a return date. So it's usually listed between 7 to 14 days after you've managed to get the injunction, unless the other person, and we'll come to that in another session where the other person has other remedies to try and get it before the court quicker. But normally it's 7 to 14 days. At that hearing, then, he or she will have the opportunity to then put their case and say, this is all a load of lies, for example. The court then has to look at the case at that point. If the court, for example, discovers that the injunction shouldn't have been granted in the first place, then it can discharge it in order for you to pay the other side's cost. Or alternatively, if the court says, no, hang on a second, there's a massive dispute of fact here. This matter would have to be considered at trial with a court hearing the evidence. Then what a court will do is it will make directions for it to go for a trial, but in the meantime, the assets would be frozen as long as there's no significant harm. What the court does do, though, it does allow, for example, if it's the other person's only bank account and they use that to pay their daily living expenses, the court will allow some leeway for money to be spent from that account to meet those expenses.
Well, that seems reasonable. Let's take an interesting example. Alas, it happens. Husband and wife are in business together, and they fall out. They want to get divorced, and husband thinks wife's going to take all his money and everything and run off, or vice versa. Can you try and freeze assets between husband and wife or partners this way?
You can, and in fact, these kind of applications are usually made. A lot of the time are made within family proceedings, where, for example, one spouse is alleging, or there's a real sort of belief that the person is going to get rid of those assets to deprive the other spouse their right to it. They usually refer to Section 37 applications, which are then made on the same grounds. You must show that there's a real risk.
So the legal.
Yeah. That one requirement I failed to mention is that you must also show to the court that if the emergency injunction isn't made, there's a real risk of dissipation, meaning that there's a real risk that if the court doesn't make this order, the other person will get rid of these assets beyond my reach.
Okay, so I got that. Now, in terms of the length of time the order, so it's going to last. You've got the order. They've turned up and said, liar, liar, pants on fire. And the judge has said, no, I don't think so. I'm going to have to, there's a dispute between you guys. Right, this is now going to go to a trial, and it could take 6 months, a year, 18 months. So effectively, the order will stay in amount of money in dispute so that balance will be maintained. Is that right?
Correct. That would be maintained until the court has had a chance to actually consider.
Injunctions.
But like I said...
Are you there?
Yeah, I'm here. I think you need to take matters up with Virgin Media for sure.
It's all happening tonight. Yes, I think we will. You couldn't have made this up.
Sorry, I didn't quite catch that last question. I don't know if you were posing me a question.
Apologies, everyone. No, I was just saying, internet is freezing and intermittent, but there you are. This is not planned, everyone. In terms of the last case that you dealt with an injunction where either you got when you have to get one, what's the best case scenario? What's the minimum that might be spent? Obviously, maximum could be tens of thousands, depending on the case, but take a relatively straightforward case. Are we looking at until the matter is resolved without a trial? So let's take two scenarios. What happens is you get the injunction. The other side eventually, after trying to knock you back, says, fair cop, Mr. Mahmood, you got me. Let's sort this out. So obviously we will want them to pay our costs. I mean, is it likely to be 5, 10,000, 15,000 pounds up to that much if it's relatively straightforward? I mean, nothing is relatively straightforward in these cases, but let's say the run of the mill. Would somebody get much change out of 10,000 pounds, perhaps more?
Well, if I give you an example, the most recent case which I did in where we obtained a freezing injunction, after we got it, there was a return date when the other side did say exactly what you said, lie, pants on fire. The judge wasn't convinced. He said this is going to have to go for a disputed trial. But that then allowed for negotiations to take place. And then the parties did settle. In that case, I think the costs that were incurred were around about £4,000, around that mark.
You're very good value for money, Mr. Mahmood.
Yeah, but what we ended up doing, although my client ended up spending £4,000, they ended up preserving over £100,000. So there was a real risk of either you spend that extra £400,000, that extra £4,000, or you risk losing £100,000. And obviously, my client took the option to preserve it.
Okay.
In this case, we managed to settle, but a lot of the time you can agree on terms that the other side at least pays your legal costs, because it was as a result of them that you've had to take this step.
Okay, so the minimum is around 4,000 to 5,000, but it could be many thousands. It all depends. Okay, that's excellent. Let's bring Mr. Saeed back into the fore. Mr. Saeed, are you there? No, hold on. No, he's not. Let me add him in. We're playing. There we go. How's that, for people? Are we good? So,
I think
it's one of those evenings. I think I need to.
Yes, it does appear as though Bashar is having a few problems.
Can you hear me?
Yes, we can hear you.
Right. Yes, it's somewhat ironic, freezing orders and freezing. I'm here. Can you guys see me?
Yeah.
Yeah.
Okay, we're back. Let's go. We'll try. We'll sort of plod on for a few minutes, and if it doesn't work, we'll have to call it a day. We'll have to injunct ourselves to stop this show. But in the meantime, guys, are you there? Hold on. Saad, you're back. Adnan, you're back. Right. Okay, so Saad, coming back to you then. With regard to whistleblowing, let's say somebody tries to throw an employee out. Could you get an injunction to get them back into the job? I mean, we're talking about injunctions. How does that work?
Yeah, so in the realm of employment law and...
Saad, are you there?
I'm here. Can you hear me? Hello? Yeah, I'm here.
Sorry.
Hello? Can you hear me? Hello, Bashar?
I think we're having a very bad day today. Adnan, are you there? Saad?
Yeah, I'm here. I am here. We haven't gone anywhere.
I think Okay. Saad, you guys. Right, both of you here. Okay, good. We're going to give it one last go. If not, I'm going to injunct myself and you guys to call it a day. Right. So while we're talking about injunctions, we made a very interesting, contribution from Saad earlier on about whistleblowing. So with regard to whistleblowing, clearly, if somebody blows a whistle and you're being sacked and you want that job back, how likely is it that you could get an order from either an employment tribunal or a civil court having you reinstated into your...
Hello, Basharat.
I think we're going to call it a day. This is... the internet is very bad today. We're having difficulty with connections, so I will...
Okay, Adnan, can you hear me?
I can hear you fine.
Yeah, I had one question for you, Adnan.
Yes, go on.
So you were talking about full and frank disclosure earlier on. Were they on Britain's Got Talent last week?
I can't say. I didn't watch it, but I'm sure you'll enlighten me.
I just thought you were talking about a duo, a singing duo, maybe a couple.
Does sound like one, yeah. No,
Yes.
full and frank disclosure means all cards on the table. You need to show all of your cards, whether they harm you or not.
Yes, indeed. Maybe we'll try and just keep it ticking along while Basharat comes back, just for a couple more minutes. He was asking me in the context of employment, when somebody's dismissed, about the possibility of getting injunctions. And just for the viewers out there, very, very briefly, it's very difficult in the context of employment law to get injunctions. If you are an employee and you're facing dismissal, or you have been dismissed, and you're seeking an order from the court to reinstate you until the final hearing takes place, or to allow you to continue working without being dismissed until a final hearing takes place, it is generally very, very, very difficult, extremely difficult, because Adnan, you outlined the tests, about whether there's a serious question to be tried, and about the consequences of ordering the injunction or not ordering the injunction, and the balance of convenience tests. In the realm of employment, it's very rare that these tests are met to the point where an employee can get an injunction to continue working in the workplace, even though an employer has tried to dismiss him or has dismissed him. So for the viewers who are listening out there, that's the answer to that question. So Adnan, I was going to also ask you a question about the injunction, the freezing injunction. So you talked that mainly it happens in the field of when couples are getting divorced or family matters. What other possible scenarios would there be, apart from the obvious one where somebody's just bought something and somebody's trying to run off with their money? What other possible scenarios could there be where freezing injunction could be applied for?
Well, like the one that you touched upon is a common example. For example, if a husband, and I'm just giving you an example, if a husband owns a number of assets which are probably in his name, marriage is broken down, and the wife believes that he's now selling them on, transferring them into third parties' names, selling off assets and shipping over money over and putting them into Swiss bank accounts or wherever it may be, that's a perfect example of a scenario where the wife would want to get a freezing injunction to stop that from happening as quickly as possible. But I've seen this across the board. It can happen between, it doesn't have to be husband and wife, can be father and son, for example. Could be amongst friends, could be amongst companies, could be in a whole range of scenarios. But the main principle is usually where someone owes someone another money or an asset, whether by virtue of a contract or some other course of dealings, and they've deprived them of that, then the appropriate avenue would be a freezing injunction, unless obviously it's outright theft, in which case that person should notify the police.
Yeah, thank you. And am I right in assuming that no matter what the situation is, whether it is a family matter, whether it is a debt, whether it's something else, the legal test is always going to be the same. Is that right?
Correct. Legal test would obviously be the same.
Okay.
In family matters, however, one of the things that usually crops up is whether or not it's even a matrimonial asset or not. So just because someone, say for example, the example I gave, a husband is selling an asset, that might be an asset which he acquired from, his late mother or father, who passed away, and it was left as inheritance, which could potentially be ring fenced, which means the spouse, it's not a matrimonial asset. But usually in those circumstances, what a court would do is it may well still freeze the asset and then have a mini trial for the court to reach a finding whether or not that asset should belong within the matrimonial pot or it shouldn't, and it should be ring fenced. So those are some typical sort of examples.
Great, that's great. Thank you very much for all the information you've provided today. That takes us beyond the hour mark. So for all of our viewers out there, I'll finish off by just giving a general disclaimer that all of the advice you've heard today is general advice. If you think that there is any situation which may apply to you personally, it's always very, very important to seek proper legal advice regarding your own circumstances. The law, as we give it in this show, is always general, and there are many other factors to be taken into account, and everybody needs the law applied to their own individual circumstances, and circumstances vary case by case. All that remains is for me to say thank you to okay, and bye-bye.